Your reading of that sentence from Dolan to Justice Thomas, I thought was a bit aggressive on the on the general rule. I mean, the court was there specifically distinguishing the general rule from the having a case-by-case determination. I thought it was articulating a general rule, but that would apply across the board. But more importantly, kind of statutory stare decisis, even if that doesn't formally apply, just we set forth the rule and Congress hasn't changed it. And this would come, I think, as a little bit of a surprise to Congress, which would probably have to address it pretty quickly. Thoughts?
So let me take each in turn, Dolan, and then why I don't think this is a surprise to Congress. So on Dolan, that sentence has a lot of hedging language, right? It also says we think it more likely that Congress intended to remain immunity. And so even if you think the court was even contemplating wrongful conduct, right? I think that hedging language does a lot of work. And if you're going to take that sentence in Dolan and say it was thinking of kind of all cases, I think you also have to take the part of Dolan where they say loss is destroyed or misplaced and miscarriage is delivery to the wrong address, neither of which we fall into. On the Congress would be surprised point, I don't think so. Again, Congress specifically did not put conversion, for instance, in the FTCA's waiver provision. Every other kind of intentional tort, assault, battery, libel, slander, all that stuff, there's an exception for. There's no exception for conversion. And so I think Congress would actually be surprised in the other direction if this court were to say conversion, liability if anyone else does it, but not if the Postal Service does it.